I'm Matt Gishard, and this is No Holds Barred. In this episode, we're going to talk about search warrants. The Fourth Amendment to our Constitution, a part of the Bill of Rights, talks about the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. And no warrant shall issue but on probable cause supported by oath or affirmation. What the heck does that mean? Well, that means that the government, and I want you to understand that all these rules relate to the government, not private people. Private people can commit all kinds of acts. They may be trespasses, they may be all of that. But this search warrants applies to the government. The federal government, state government, local governments, that's what it applies to. And we hear about search and seizure issues all the time, and they all go back to the government action and the Fourth Amendment. So what is probable cause? So probable cause, the idea that did a crime occur? So in order to be secure in their persons and places against unreasonable searches and seizures, no warrant shall issue but upon probable cause. That means there has to be probable cause, a reasonable cause that a crime occurred. That's important, that there is probable cause to seek a warrant. And seeking that warrant, it's supported by oath or affirmation. So for any of you who've ever seen a search warrant or know about it, there is a warrant that's filled out. Essentially, this is what we are seeking, this is why we're seeking this, all of that. And then there is an affidavit, an oath by a police officer. And those two go together. They go before a magistrate, and the magistrate reads that and determines whether or not the magistrate, judge, is going to sign that warrant. Now, in practical terms, we hear this all the time. Many times you'll be in court and see somebody will approach the judge and ask for a little time and go into the judge's chambers, and the judge is looking at a warrant, reviewing it. Or at night, there's generally a judge who's on call in our county and in all counties any time of the day or night to review a warrant and to see whether or not they're going to sign that warrant. In most cases they do. In some cases they don't. Maybe they'll send the police off for additional information, believing there isn't probable cause for that search. But at any rate, it's the government search. And what are they searching for and seizing? So it's an interesting topic. It's an important topic because we think of searches and seizures in all kinds of situations. Car stops. May I search your vehicle? I'm going to search your vehicle. Coming to your house, looking for your phone records, looking at your bank records, going into your house for any purpose, going into your garage, doing anything that relates to a search of you or your property and seizing of evidence. We learn in law school something called the fruit of the poisonous tree. And let's say there is a search that is not supported by probable cause, and there's a seizure of property or evidence, the gun in the trunk of the car, the dead body in the trunk of the car. And that would be excluded because there was no probable cause, and therefore the search is improper, and therefore the seizure is improper. So it implicates the same rights and duties when we look at a search at Mar-a-Lago. So the government went to Mar-a-Lago, to Trump's Mar-a-Lago, with a search warrant based on probable cause and oath or affirmation, and they seized documents, the documents they were looking for. FTX, we talked about FTX and that fellow who had the company that failed. There was a search, lots and lots of documents, lots of evidence. That famous Idaho case where the young Students were killed in Idaho. Eventually they caught a person. There was a search of that particular house, a search warrant. They had a police officer stand out front while they went and got a warrant to secure the place and went in, but they did not search that house without a warrant. Jeffrey Epstein's papers, that famous case of Epstein and the IDs of all the various people that have flown on his planes and all that, that required a warrant. So they all implicate the same rights and the same responsibilities. So when we talk about cell phones, let's talk about that. Somebody is stopped for DUI. They are arrested for DUI, and the officer, question is, can the officer search their cell phone without a warrant? The answer is no. Can the officer search that cell phone with consent? The answer is yes. So the officer may say, I saw you. I thought initially you might have just been using your cell phone. I smell the odor of alcohol. I'm going to arrest you for driving under the influence. But I'd like to search your phone and see if you were on your phone at the time. And if the person says, sure, go ahead. You have consent. Then there's no need for a search warrant. However, if the officer wants to search that phone, he must have probable cause. And what would the probable cause be after you've arrested somebody under the influence of alcohol to look at their phone? There may be some reasons, but I suspect that a judge might say, no, I'm not going to allow you to search that phone. There isn't probable cause. So arresting somebody in a vehicle. Now, the rule is that you may search the immediate area of a person that you've arrested for your own safety if there's a gun or something like that. But arresting somebody for driving under the influence does not allow the officer to search the trunk of that vehicle, because that can look under the seat and there's a bottle there, okay, or something in plain view, an open container, anything in plain view that's a violation of the law. Don't need a search warrant, but a search warrant to search that vehicle. So in many cases, somebody is arrested for DUI and they impound the vehicle. And they do what's called an inventory search. Well, we don't want to be accused of taking anything. So we do an inventory search of the impounded vehicle, and we opened up the trunk and there's a dead body in there. Good question as to, can they do that? Can they do that? And is the evidence of that dead body excludable, or did they have probable cause without a warrant? Or do they seek a warrant? We're going to do an inventory search, but we're going to seek a warrant. Here's the reason why. And do they have probable cause to get a search warrant? So all of those things. An interesting thing that comes up is exigent circumstances. So searching somebody's home, if neighbors call and say, we heard a bunch of shots go off at our neighbor's house, lights went on and off, we're very concerned, we've called them, nobody answers the phone, the police arrive, they say that would be exigent circumstances. We can enter the residence, we must, for public safety purposes. We need to go in and see, is there somebody in there who's alive or dead or needs some help? So we call there reasons why a warrant would not be required under exigent circumstances. Once somebody's in a house under exigent circumstances, and let's say they see a whole pile of cocaine on a table, that's in plain view. They have a right to be in the residence because of the exigent circumstances. They see that pile of cocaine. It's apparent it's against the law. Do they have a right to seize it? In fact, they do, because it's in plain view. So those are kind of interesting things about the idea of a search warrant. Now, I will say, I've had several cases in which somebody got in an accident. They were obviously under the influence, because the witnesses and people that were also involved said they were. They tried to keep them from leaving. They were unsuccessful in keeping the drunk driver from leaving. A person's car was capable of driving. They drove it home, ran into their house, locked themselves in their house, and didn't answer the phone. The police came and knocked on the door. They have no right to go into that house without a search warrant. So the person who committed that act of driving under the influence and getting in an accident, in effect, probably the best that could happen is they could be charged with a misdemeanor hit and run, unless somebody was injured, and then potentially it could be a felony hit and run. But those are interesting questions. Now, what if two roommates live in a house? The police come to the door and say, we'd like a consent search to search the resident. And one of the roommates says, sure, come on in and search. And another person says, no, no. Now, the search may be limited in scope. The person who said no is, you can't search my bedroom. You don't have probable cause to do that. But the other person says, well, I'm going to let you in and you can search all the common areas in here. You just can't search his bedroom. So that if there's something seen in plain view. I always kind of laugh, and I actually used to tell my kids this when they were in high school going to parties. If in fact you're at a party and there's alcohol being consumed and there's a knock on the door and a policeman is standing there, perhaps because there's too much, I want you to get as far away from any alcohol as you possibly can. And certainly don't be holding a beer in your hand, because the officer can look into that residence and see juveniles in possession of alcohol, and that is a crime, and the officer does not need a search warrant to enter and question that particular individual. So you often think of people saying, you can't come in, you can't do this. Well, yeah, if there's a crime that's apparent in the officer's presence, the officer can without a warrant. But so we're talking about reasonable suspicion. What about at school? Now, there's some very interesting rules at schools in the state of California. I had a case at one time where some firecrackers or fireworks were being set off at the school by some students. The school personnel then went and asked a whole bunch of the kids. They said, okay, we're going to search all of your backpacks. You all have backpacks and your lockers. And the school went ahead and did that. In one of the backpacks of one of the boys was a pocket knife. It was against the law to bring a pocket knife on campus. And the school then said, well, we had a right to go in there without a search warrant because it's for public safety reasons. And we had a reasonable suspicion that there were fireworks in that backpack. So you can see that on school, there's a heightened ability to actually conduct searches. So if the search, however, is illegal, then the evidence is excluded. It doesn't get to come in. And that goes back to the fruit of the poisonous tree. How about wiretaps? Anyone watch The Wire, that wonderful show that was on for a period of time? Well, that involved a search warrant in which the police got a warrant to tap telephones. And it was very limited. If you watched that show, it was very limited. It could only be for a limited period of time to listen in, and then for a longer period of time if requisite statements were made. If not, you had to stop. And so a warrant was needed, and in fact, a warrant was issued in that case. Interesting case to watch on the issues of that warrant and the limitations of that warrant. Search warrants at the border. How about a search at the border? And we often see that. There are many shows of people coming across the border. Please go over to that line, and the authorities search the car. And they say, well, without a warrant. But warrants are not required at the border in the United States. That's another one of the reasons that search warrants are not needed. But how about a search incident to an arrest? So somebody is arrested. The officers have the ability to search that person for any weapons or any contraband for the officer's safety, and then in the immediate area where that person was. So incident to the arrest, where they were in their car under the seat, but not the trunk, unless there is some probable cause that leads them to believe, let's say, they arrest somebody, get them out of the vehicle, pat them down, and then they smell the strong odor of a dead body, marijuana, something such as that, and it comes from the trunk. They have a right to open the trunk and investigate that. Impounding cars, as we've talked about, that's important. How about DNA? Now, that's an interesting thing. We have the Golden State killer, whatever they call him, and he was discovered by the use of DNA through whatever, some Ancestry.com or whatever. Interesting that the authorities they surveilled him and then got garbage from a garbage can that was put out by him on the public sidewalk, in which he would have no expectation of privacy. From that garbage was taken whatever, Coke cans, pizza, whatever, that then had his DNA, compared that DNA with what they had, and found that he, in fact, was the individual. So no search warrant needed for something where there's no expectation of privacy. It's put out on the sidewalk. If, in fact, the garbage cans were in the backyard and they wanted to do that, they would have to show probable cause for searching something on private property where there is an expectation of privacy. Cell phone records, absolutely, and we hear about that all the time. In order to obtain somebody's cell phone records, and I will tell you, we've had several murder cases that I can recall in which it is believed the person was in the area. They've recovered their cell phone, and they want to get those cell phone records and see if, in fact, those cell phone records by whatever, triangulation or whatever, that the person was in that particular area. And we hear about that all the time, that in fact, the cell phone's record indicate that the person made a number of calls. In fact, that cell phone, by triangulation, was in the area of the homicide, putting two and two together. But you need a search warrant to get those records. DUI checkpoints, that's an interesting one. That's kind of like a border search. So the government is allowed to do DUI checkpoints. They call it license and registration checkpoints and DUI checkpoints. So you're supposed to have a license and registration on the road. You're not supposed to drive under the influence. So they announce that they're going to have on certain nights. It's going to be in certain areas, and they have a right to stop. In many cases, they do like every third car or some random kind of a thing. They stop people, and they have a right to stop them and check their identification. And if they smell the odor of alcohol, get them out of the vehicle. Initially, when those happened, they said, nope, you need a warrant. No, you don't. You can actually do that as long as it's done in this particular pattern. It's randomly done. It's announced ahead of time. So very important about that. A critical issue has come up more recently in the use of drones. So can the government, and remember, all of this relates to government action, not private action, government action. Can the government take drones and fly them over your property to determine whether or not you have contraband in your property without a warrant? No, they can't. No, they can't. Now, drones are often used in situations where there's a barricaded suspect, there's a house fire, there are all kinds of things, and the drone is flown over that private property to gather information about the fire or about the person inside or whatever. But just flying one over to see whether or not somebody's growing dope in the backyard or not. If they need probable cause, they need a warrant. Let's assume that a neighbor calls and says, you know, my neighbor is growing marijuana in his property, and I know he's doing it illegally, and you can see it from my house. And so the police are invited in by a neighbor. They can look over the fence without climbing up on a ladder. Just look from the neighbor and see. Then perhaps that allows probable cause without a warrant. But if the neighbor says, my neighbor, I believe he's growing marijuana or he's doing something, and I want you to do something about it, perhaps there is probable cause that can lead to a magistrate signing a warrant and the police entering based on statements of the neighbor or information that they have gathered. So what we talk about, the United States Supreme Court has indicated that drones cannot be used simply for surveillance, but they have not yet ruled on that expectation of privacy. So we haven't seen a United States Supreme Court case on that you cannot use drones. We've seen many others, but I suspect at some point we are going to get to that state where the U.S. Supreme Court will rule, because different states are ruling in different fashions about the issues of search warrants, when they're needed and when they're not needed. But as we get into all the kinds of interesting electronic issues that we have, texts, cell phones, social media, you can see more and more where the issue of, is a search warrant needed? Now, certainly in civil cases, we have oftentimes, we need to subpoena records, and we can subpoena, say, bank records. But if the government wants to get somebody's bank records, and whether it's Rudy Giuliani's or Donald Trump's or Joe Biden's or Hunter Biden's or anything, they need a search warrant based on probable cause in order to look at those records. And again, there must be a lawful reason. And it is something that we're going to continue to see. So keeping in mind, they can't search and seizure. So when something is found to be an improper search, it's called, under the law, it's an unreasonable search, and it's an unreasonable seizure. And again, I'll go back to, as much as the dead body that's found in the trunk of a car when the police improperly search it, that would be excluded. Now, does that mean that the person is not guilty of the murder or that the police can't investigate? Certainly not. In many cases, they find additional evidence. So I do want to go back and say something that's kind of related, is when we talked about the Miranda case, how that worked way back when in one of my no holds barred, and Mr. Miranda was in custody and he was not given his rights, and statements were taken, he confessed, and at some point, all of that was thrown out. And I think the irony that people don't know is the government then tried him again, not using that evidence. So that evidence was excluded, but other evidence was put in, and he was, in fact, convicted of whatever, I think it was kidnapping and whatever else. And so Mr. Miranda spent a lot of time. But that is the same concept as the fruit of the poisonous tree. You can't use it if it was illegally gotten. You can't use statements from people if they were illegally seized. You can't use property or evidence if it was illegally seized. In order to be legally seized, unless you have consent of the party or it's on view or some of those exigent circumstances, it requires probable cause and a neutral magistrate. A magistrate is a judge looking at it and agreeing that there is probable cause, reading the oath or affirmation, that is, declaration given by the government official, issuing the warrant, and then based on that, the search is made. I'll give one final kind of example of how things happen, even when there is a search warrant. In some cases, the search warrant is limited to the daytime. In some cases, the court allows the nighttime. And in many cases, there is an issue of knock and notice. So in general, there's supposed to be a knock, knock, knock a number of times, identifying yourself as the government, as police officers, and asking for entry. And then you have the search warrant. However, in some cases, because of the concern that any contraband may be flushed down the toilet or not, and the statement is made, and the judge then gives permission to forego the knock and notice, and in fact, make a night search. So there are a number of circumstances that can also result in search warrants, but certain limitations or opening up certain ways in which the police can conduct their business in searches and in seizures. So that's a broad topic, and there's an awful lot more. So if you have any questions or comments at all, please enter them below. And if you like this, please hit the subscribe button and hit the like button, and stay tuned for our next episode of No Holds Barred. And what I'd like to say about No Holds Barred is no hyperbole, no bullshit, just the law and the facts. The reason why we like you to hit the like button and the subscribe button is because it helps us with our YouTube rankings. The more people that do that, the more people will watch our episode, the more comments we get, the more questions we get, the higher we go in the rankings. It helps you, and it certainly helps us.